Well, hello everyone. So we're just gonna listen to a little bit of music until people start coming in and let me know. We're gonna have a special guest tonight, so I can't wait for you guys to meet her. She's a wonderful person. She's my girl. She's my ace boom boom. Yes, she is. Yes, she is. I drink you too, you girl. It's a big surprise. We're gonna talk about emotions today, but we're gonna get into it in a little bit as soon as more people start showing up and let me know they're here. So I need everybody to tell me what good thing happened to them today or this week or the last time I saw you. Just any good thing. It was a sunny day. You woke up. Let me know what happened. Just type it in and just tell me something good that happened to you. Okay? In the meantime, Tammy gonna get her drink on. I can't help it. It's a crazy day today. Real exciting day too. Something happened that was wonderful for me. Not so much for a lot of other people, so I'm not going to bring it up. Yay. But anyway, I'm drinking to it. Thank you, Jesus. So how's everybody? Hey, Brenda. Great sunny day here. Where are you from, Brenda? It was crazy weather you were having here in Pennsylvania. One day it's 75, the next day it's 22. That's what we do here in good old Pennsylvania. That's what we do because we're crazy. So, oh, you're in South Carolina. Hey, South Carolina, how you doing? So, anyway, did everybody see my T-shirt? Yeah, that's me. I can't help it. I'm not for everyone. Okay, it is what it is. I don't know what I'm doing, so I just can't. The lighting in here is, I don't know, is the lighting okay, guys? I'm looking at it, I'm like, it keeps going in and out like it's crazy. Let me see. Oh, I don't know, it's good. I just upped my ante and now I'm getting 1080p and I'm hoping it makes a difference because it looks better, I guess. I don't know. But anyway, my name is Tammy Joya and I'm an advocate for children with special needs. I've been doing this for about 25, 30 years, somewhere around there. I go all the way up to hearing and sometimes I actually end up in the courthouse, but it's for different things too, regarding children with disabilities such as guardianship, paperwork. I know how to fill that out for you guys. So anyway, tonight is going to be a real exciting night. We're going to talk about emotions. We're going to talk about literally filing it. I'm going to show you guys some really good things, some examples of what I've actually done. And we're actually going to have a parent here tonight who's going to give you her view about going to hearing and what she's experienced and would she do it again, and if so, why, and a whole bunch of stuff like that. So we're going to put her on in a few minutes. So I hope everybody can join us. It's going to be a good night. I worked hard to get the paperwork set up so I can show you guys everything. So stay tuned, and we're just going to do it. So just let me know what you guys have been doing, and it'll be okay. I'll give you about 5 more seconds, and then we're just going to go get my guest. My special guest tonight her name is Barbara Langois, and she has been my client for approximately 10 years, maybe more than that, not sure. It's been a fight all the time. It's been a fight. And sometimes it's been me and her fighting, but we get the job done and we get the kids situated. So I'm gonna this was a surprise thing. I wasn't gonna do this so everybody didn't know. So I didn't put it out. It was a last minute thingy. Hey, Megan, how you doing, girl? So this is gonna be exciting. I'm gonna use a lot of her documentation because Lord knows we've been in and out of hearings like nobody's business. So let's get to it. I hope Barbara's ready. And so we're going to put her out there so we can talk, okay? I'm going to ask her some questions. And if you guys have any questions for her, please, at the end, just ask us. It doesn't matter. Just ask us some questions. And all you have to do is say, hey, Tammy, this is for Barbara, okay? And then we can ask her the questions. So, Barbara, can you see the chat? Barbara, can you see? Oh, you can't? Okay, so I'll ask the questions if it comes up and it's for you, okay? So let's get to it. Let's go and find out what's going on, okay? Here she comes. Everybody, I'd like to introduce you to Barbara.
Hello.
She's been my client since, like I said, I think 2012. somewhere around there.
It's
to
been a
present.
while. Yeah.
It's been a while. And so I became her advocate when her son was about 12 years old. He's now 22. He's about to be 23, isn't he? No.
Yeah. Well,
Is he?
yeah, July.
Yeah, in July he's going to be 23. So and I'm still with her, even though he's not in school, because now it's not so much idea, it's more ADA, okay? And his placement, and there are laws that protect him there too. So I'm still involved, and I love doing that part too. I have more fun with the adult than I do with the kids. But anyway, so Barbara, I don't even know where to start with you. Like, what's a good question? So, like I said, we've been doing this for 12 years old. So, since 2012. So what, this whole segment is about going to hearing. So can you tell everybody like how many times you've been to hearing?
Okay, correct me if I'm wrong, Tammy. I think it was twice. I believe it's twice we've been to hearing, sort of.
Kind of, sort of. Let me do it this way. Let me ask you this way.
Okay.
How many times have we filed? We filed
a lot. We filed a lot, and then we got what we wanted
without going to hearing.
Right. But the first actual hearing we went to was last year because of my son's ABA. The ABA report that was done wasn't done correctly.
Sorry.
No, that's okay.
I forgot.
That wasn't done correctly. So we had to fight for the private school and the school district to reconsider to do an FBA on my son.
Was that you're talking about recently?
Yeah.
Okay. Okay. So that was the recent one, and that's the one we won.
Yeah.
You guys, this is the case I just was in, and I just won. And what happened is the ding dongs decided that even though the mother requested a functional behavioral assessment in the community, because the kid's turning 22, they decided, well, we don't need that. We're going to do this other thing instead. So then I said, oh, really? You think no. So we filed for a hearing and we won. So when we won, what happened was that the school district was ordered to get that same person that did that same BCBA who screwed up the first one because she was all of that in our bag of chips, apparently, who didn't do the evaluation that the mom consented to. She told the school district, go get her and make her do it again, this time in the community. And so that's what happened with that case. And that's how we won. But my thing is, so in the past, so we had one hearing.
Right.
And we won.
Yes.
But, for instance, how many times is your kid in a program in a private school?
Okay. Let's see. He went from what was a 30-day assessment, a 30-day, 45-day assessment. 45 days. Where, yeah. So he went there, and then.
And wait a minute. That was because of a hearing.
Correct.
We went to a hearing. And we did a pre-hearing conference call with the hearing officer. And the hearing officer, after hearing what I had to say about what the school was doing, he told the school district, listen, if you think the hearing is bad, if what she's saying is true, you guys are going to have way more problems. Because what I told the school district and the hearing officer was that the parent has given me permission to release all of her kids' records to the injured party. Right. And I told the hearing officer, I told the parent that I would testify on behalf of the injured party, that her son injured because they don't listen. And so the hearing officer told the school district, you better listen to her, because if that's what she said, you're going to have way more problems than this state hearing. You're going to be in court.
That's really exactly like you just said. He went into this 45-day program. It was to assess his behaviors. He was doing the same thing there. They didn't want him there anymore. He said, get him out.
He couldn't have 45 days in a program that allegedly was designed for him, for kids like him.
Right.
He has autism. And it's severe. He's globally delayed in all areas of functioning. Okay. So, hey, Amanda, how you doing, girl? So I just wanted to tell everybody, if you have any questions for Barbara, just feel free to pop them in there and I'll ask them. She can't see the chat right now.
No.
Okay. So just feel free to go in and just ask her questions and I'll ask her for her. So Barbara, after you did that, so what ended up happening?
Okay. After that, he went into a day program called the League School.
We won that program, right?
Yes. We
went without going to hearing.
Correct.
Because of the shenanigans that went on at the 45-day assessment.
Correct.
So we didn't go to hearing on that one either, did we?
No.
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 So, and then he stayed there for what, about a year?
Yeah, often I think it was less because
really
he was they said that he was in the hallways. He wouldn't go into the classroom. So they said, well, it's not doing okay. This program's not working out for him.
They didn't want him there. They couldn't educate him either. So now we're back at the drawing board. So now, but see, here's the cool thing. Because I have seen that play out in real time with my own kids. Exactly. So yeah, one of our participants just said, I have seen that play out in real time with my own kids.
Mm-hmm.
So because we got him into and now that was a day placement, right?
Right. That was a day.
You guys keep it. Get this. We started off with a 45-day diagnostic that I filed for a hearing for. It never went to hearing because from the 45-day diagnostic that the school district agreed to put him in. And the diagnostic is that this program was going to assess to see, if they could keep him there. So they were going to do an observation, and they did. They did the report, and the report came back, and it was not good.
It wasn't, no.
Because you see, these people didn't want to pay for him to go to a program, even though, I don't know if I should tell them. The stuff about your kid, I don't know,
Yeah.
I'm talking about Pembroke.
Well, yeah, if I don't want, I don't want
people.
No,
it's okay.
Yeah.
Well, there were things that were going on that the school district was well aware of. And see, you guys, you have to understand something. If the school district has knowledge of things that goes on with your kid, and then they do nothing, that is so bad. And that's why we ended up getting her kid into a program, because, I played that to the fullest. By the way, guys, I want you to see my thing. Can you see it?
Not
because I'm that girl. So imagine that. So because we got him in one program, and that program said, absolutely not. He can't even stay here. That was a day program when it was only for 45 days. But because we got that, well, it's not funny, Amanda. Because we got that, then, thank you. It was easy to get the next day program. But then we get the next day program.
Well, it was after that, it was Amigo.
Then these are all schools, by the way, guys, in Massachusetts. One thing about Massachusetts, they have a whole bunch of day programs. And I know you were laughing at my shirt. I'm not for everybody here. So anyway, me and Barbara were just having at it because I was mad because she wasn't doing something. She told me I was mean. Everybody tells me I'm mean. I don't care. I am mean, but that's what you guys love about me, because I'm mean. But anyway.
I'm just so glad you're on our side.
Kelly sees you. Yeah, thanks, Kelly. That's what a lot of people say. I actually had a school administrator say that for Cardinal Cushing. And she said, man, I'd hate to be on your bad side. And guess where she was at this year? On my bad side.
Yeah.
It wasn't good. But anyway, so we ended up, how many day programs was he in? Do you remember?
2. It was I would say, it was about 2 actual day programs, the 45-day diagnostic, then then the residential.
Right.
That's how it went.
Then because he was they just didn't know what to do with him. And the reason why let me tell you why they didn't know what to do with him. Because they were stupid. Because the second placement, I think, or the first placement, the league, we found out the league was using, wait for it, ABA approaches. There's no such thing. Listen to me, you guys. There's no such thing as ABA approaches. There's either ABA or there's not ABA. No approaches. You understand? The approaches. You either do it or you don't. That's like being a little bit pregnant. You can't do both things at the same time. So that's when we found out, because they come to a team meeting and they say, well, I said, wait a minute. This school is filled with kids with autism. Filled to the rafters. And they come to the table and I said, wait a minute. You guys said you have ABA here. It's not funny. You said you had ABA here. So do you do ABA or not? And they said, we do ABA approaches. I said, pack his shit. We're leaving. I turned to the school district and I said, that's it. I want a residential for this kid. This is ridiculous.
Yeah.
Now
so he got that. He did get the actual residential when he was 17.
When he was 17.
He lived with us all that time.
All that time. Okay.
And it was
hard. Was it hard on you guys?
Yes. Yes.
Hey, girl.
It was hard on you guys? It was really difficult, very stressful, let me tell you.
What about, how is the stress level when you know your kid's not getting the services that they need? I mean, as a parent, can you talk about like your feelings? I'm an RBT. Okay. Amanda says, and she's an RBT. That's a registered behavior therapist.
Wow.
Yeah, so you know what I'm talking about. Stephanie Ponte, we got an N1. Okay, N1, that means it's Massachusetts. This is what one of the people just said, Stephanie Ponte. We got an N1 after an IEP meeting that said my child needs a language-based program. The rest of the proposed IEP did not mention it because they're stupid. And that's a denial of faith. I can tell you right now, it's a denial of faith.
Yeah.
I rejected the parts of the IEP that didn't reflect the placement of the LB program. Once the rejection was sent, within 2 weeks, I got a revised N1 that said the original was a typo. It says the original was a typo, and the district completely changed their opinion.
Oh my God.
Isn't that weird?
Are they smoking something over there?
Yeah, they're in Massachusetts.
It's a typo? Are you kidding? Oh my God.
Stephanie agrees with you. She says that the stress is unreal. I feel like I have the stress levels of a combat soldier. That's from one of my.
Yes.
Yeah.
You got to have tough skin. Okay. That's
my
number
girl.
one.
What did I tell you? The first thing I said, what did I tell you? You can't, what they say doesn't matter.
Right. Whatever anybody says to you, who cares? That's it. You can't worry about what everybody thinks. If you do, you're going to be messed up. So first, what Tammy told me, you cannot care what anyone thinks about you or your children for that matter. So you got to keep moving forward. You got to keep on your feet and make sure that you're advocating for your child. That's what we had to do. That's what we did. That's what we had to do every day.
Every day.
And I did not care what anybody thought. After I realized that, I felt better.
Yes, because you know why? Because you got confidence. Because you knew after a while, I believe, you knew after a while, you had right on your side. And Stephanie says, I absolutely agree with you. And she said she can't make this stuff up. That stuff I just read. She said, I said, I know.
You can't.
I just chewed out the school district. Okay. She has 2 kids on IEPs. It's a hot mess.
Yeah, it is.
It's a hot mess. Oh, guys, I got to tell you this. This is funny. Okay. So when I first met Barbara, we went to team meetings. And this one was about her son. And we go to a team meeting. Barbara is sitting way at the other end of the table, and I'm on the opposite end. And so we're trying to do the team meeting about, the evaluations and stuff. Okay. I got to fix my lighting. Okay. So Barbara gets mad because they're not listening. She punches the table and she said, fuck this. That's what she said. Okay, loud. I hope all the kids are in bed. Barbara said that real loud. And I was at the end of the table. I said, Barbara.
It was emotional. Like, finally, somebody got it.
Yep.
Tammy got it. Of all those years without Tammy, somebody finally got it. I'm like, there you go.
Because she knew she was right all along. But she needed somebody else sitting at the table that's telling them, have you lost your damn mind? Mm-hmm. Amanda said, ooh, Barbara, I slammed my fist too, LOL, before. But there was nothing I could do to stop her. So I started laughing.
It was like this, like, yes, like,
what is wrong with you people? Barbara was pissed. It happened twice.
Yes.
To be real, it happened twice.
I mean,
the second time it happened, didn't you tell them? Didn't you get up and say, I'm done with this stupid meeting? And you walked out?
Yeah, and they kept on saying to Tammy, can you get your client to sit down? And then Tammy said, Barbara, are you going to go sit down? I said, no, I'm out of here. I'm all done with this meeting.
Wait. That's not what they said.
Oh, okay.
Because Barbara was slamming her fist on the desk again, saying the F-bomb, dropping it like it's hot. Okay. So I'm laughing. And the sped director was sitting right next to me. Barbara got up this time. She said, I'm out of here. This is stupid. I told her, well, that's how you feel. Stephanie says you are not listened to. That's right. That's what Stephanie said. So I said, I'm still sitting down. Barbara's already at the door. Yeah. I'm still sitting down and I'm laughing. And so the sped director looks at me and he goes, Tammy, are you going to get her to sit down? If she acts, if she behaves and she doesn't swear, then we'll continue with the meeting. I'm like, there's a reason why she's at the door.
I forgot he said that. I forgot he said that.
I was cracking up. So I looked at him. I said, have you lost your mind? I said, she's done.
Yeah.
I said, wait, I'll ask her. I said, Barbara, are you going to behave at the meeting? She looked at me. She said, no. She walked out the door. She was gowned. She walked right out the door.
But it's the constant thing with these team meetings. These team meetings are just bullshit. I'm sorry. They're complete bullshit. They don't follow the laws. They make their own laws. They do the reports are bad, and they have people reading the reports that are not supposed to read the reports. And then they don't have the people in the meetings that are supposed to be there.
Nope. So
it's illegal. And
the whole thing's illegal, and then we have to start all over again. But what happened was he did end up in a residential. Unfortunately, even though we won, we lost because they didn't teach him shit. Mm-hmm. I mean, he cannot make a bologna sandwich. Correct. I am not kidding. He cannot make a bologna sandwich, and there's absolutely no reason why he can't. The reason why he can't is because that school didn't do Jack Doodley squat. They have over 15 BCBAs. What we did find out through testimony in the hearing is that the woman that's been working for a kid for 2 years, she doesn't have a license. In Massachusetts, in order to practice as a BCBA, you have to have a license. She didn't have one at all for 2 years. And it's in the testimony, in the transcripts. And I asked her, who is your supervisor? And I asked her, how many BCBAs are at that school? This is a private school that cost the school district $1 million. Her son, he can't shave. He can't wash. He can't use a wash machine. He can't do nothing. And now the program where he's at through the state agency, he lives residentially in an agency, a group home. They don't know what to do with him. But these stupid people from the agency were sitting at all of his team meetings. And you know what they did? They didn't say a word. They knew he wasn't learning it. That's awful. Yes, I check the license always. So now I'm going to do a few things. I'm going to let you know what I did later. But I got something for them. Yeah.
I know.
But, so Barbara, let me ask you a question, because a lot of parents that I've represented or I've talked to, they're all gun-ho. Let's go to hearing. In your experience, what is going to hearing? What is that like for you? In the number of the hearings that we did, that we actually filed, even if we didn't go, what was it like for you as a parent?
Very, very stressful. Yeah. Very.
Right.
The back and forth nonsense that went between you, me, and them, the school district, constant. It was a tactic that they used to not go to hearing. But then at the very end, they budged and said, oh, yeah, we'll give it to you because of all this back and forth. And I'm telling you, it's so stressful. And
didn't I have to explain to you why we were doing the back and forth though?
yes,
And every
yes.
way, because you see, I was told, and I know this for a fact, a good litigator never goes to hearing. You usually, what I do, I consider myself a good litigator.
Mm-hmm.
Because
Yeah.
what I do is I try to get everything that I need for my clients without going to hearing. Okay.
Yeah.
If you can do that, you're gonna know. If what you want for your kid is what you get after you file the hearing, but you don't actually go to hearing, you won.
Mm-hmm.
And I know, guys, it's hard. Do you feel like you won though? Anything?
I do, because my son went into private placements, day programs. Thank God. But still, we had to have him at home till he was 17. But when we actually went to hearing, that was stressful enough. The actual sitting there for 8 hours, listening to their testimony, was like, really?
Guys, Barbara didn't have to testify. That's how bad.
Yeah.
That's how bad it was. She didn't have to open her mouth. I never called her as a witness, and they didn't either. I had what, 4 or 5 witnesses?
Yeah.
We did her hearing we started at 10 o'clock and we ended at 5:15. And even the hearing officer thought we were going to end then. I said, oh no, we're out. This is not going to be more than 1 day. This is easy peasy. But yeah.
The thing was, like, even when you did that hearing, we had to do the back and forth for a little while. And then all of a sudden you say, no, we still don't have what we want. We're going to hearing. That's how it happened.
We just keep pushing it. We stand our ground. We stood our ground.
Yeah.
And we got him, like, right now, he's in a good place right now, we think.
Mm-hmm. Yeah.
And we think we can handle it better because now we're more into the ADA violations or the ADA regulations as Americans with Disabilities Act. So we will be able to do more. It's easier when they're older to make sure they get the things that they need because there's so many services that are available to them. And we'll get into that. That has to do with transition. We'll get into that later on in my little things. Mm-hmm. But because I've talked about transition, but not into adulthood. So that's where Barbara is right now with both of her kids. One is already aged out and the other one is about to age out within the next year. So that's where we're at right now. And we're going to have Barbara on again so that she can tell you, her perspective. Barbara, if you, did you have any other advocates besides me, before me?
Yeah, I had a couple of them, but they didn't work out. They kind of befriended the school district. They kind of sided with them, and that kind of messed everything up. That's not what, from my own personal point of view, you don't need a friend, and your school's not your friend. You have to go after them. You have to file a complaint. You got to go to hearing because they're going to lie to you. They lied to me for years. If I listened to them, my son would be in prison. That's it. He would be in prison. There's no question to make because I said to them, I said, you're lying. You're not telling me the truth. And that's when I got Tammy after like maybe 2 advocates before you. And they didn't want to file complaints. They didn't want to go to hearing, nothing.
One of the things that Barbara asked me was, how come my other advocates didn't do this? This is why I tell parents about getting an advocate. Your advocate has to know 3 things. They have to know the laws. They have to know the procedures. And they have to know your kid's disability and how your kid's disability impacts how your kid accesses the general curriculum. Okay? Because if your advocate doesn't know that, and just knowing the laws, is not enough. It's just not enough. There's so much you have to know about being an advocate. It's I don't know why my thing is doing this. Okay. It's a pain in the butt is what it amounts to. But anyway, I want to thank you for coming on, Barbara. Just go back to joining the rest of the thing. I don't know how you have to get out of this.
Okay.
But you can go back into the chat. And I want to thank you guys. I want to thank you guys for allowing me to do this. And now we're going to get into the other stuff that we actually came here for. So
okay. All right. Bye-bye.
I'll talk to you later. Okay. Bye-bye. Okay, guys. So now that I'm a little buzzed, I'm feeling pretty good. No, I'm kidding. I'm not buzzed. Anyway, so what I want to show you guys right now, because I told you we're going to talk about the hearing shit, right? Whoops, excuse me. Didn't mean to say the bad word. So what I'm going to do is I'm going to start doing the screen share right now. Okay. So here. Okay. So this document right here is exactly what it is. This is what I have to do as an advocate, okay, or a parent. So when you guys want to file for a hearing, okay, you have to go on your state's website and get this form. Every state has them, okay? They have request forms. See that right there? They have the hearing request forms. Now, what you do is you type in your state's, what do you call it? Your state's special education. You put Illinois Department of Education and you put Department of Special Education, okay? Or you can just put in Illinois Department of Education Special Ed Due Process Hearing Form. That's all you have to do, stuff like that, so you can get it. If you're in Mass, could you share your advocate's name, please? Thank you. Honey, that was me. I'm her advocate. Is that what you're asking? I'm still her advocate. We're still in a lot of stuff. Okay. And she is in Mass. So anyway, so what you'll get is this form. All right. And this form is basically, you have to fill out this form. Okay. Thanks so much for sharing. No problem. Barbara, she said, thank you so much for sharing. Right there. Barbara, if you can go on and you can answer them now if you want. So anyway, so what you do is you'll get this form, okay? And you have to fill out this form, okay? This is one of the reasons when hearings, the school district's attorney will come back and say that your due process hearing complaint was insufficient. This is what they're talking about right here. One is you didn't fill out this information, the student's name, the student's address, who's representing you. All of this information is what you have to fill out as the cover sheet to your complaint, okay? Now, this is what I did. So when you get down to the nitty gritty, when I write a complaint, and you're going to see in a minute, my complaint is intensive, okay? And so there's not enough space. There's not space. So what I do is, see, it says incomplete information may limit the scope of the hearing. So you got to make sure. Thanks, Barbara. So you got to make sure that don't make it too big, but that you cover enough issues that it's going to be heard. Okay. So this is the first thing it says: failure to provide complete information. I just said this to you. Okay. Here, look at that. What? Okay. Failure to provide complete information may result in a challenge to the sufficiency of the hearing request. I just said that. Okay. I didn't even realize that was on the form. Okay. So then it goes down. And so you got to make sure you fill in as much as this as you can. Okay. If you have a representative, you have to check off if it's you, representation information, if it's the parent, the name of your advocate or attorney. Now, for the parent information, if the parents are together, just put in the mother, put the name of the parents, put your name, the mom, and then go down here and just write put the father's name and just write same. If you're doing this yourself, you don't even have to include your husband. Okay. Just saying. Most parents, I just usually put the mom's name, whoever I'm dealing with. Excuse me. My voice is all screwed up because of allergies. I can't stand it. That's not helping. Anyway, the parent information, it's whoever I'm dealing with within the family. That's what I put there. If you're filing it, just put your name. If you want to put your husband's name, do that too. It doesn't matter. Do what you got to do. Okay. So then it says down here, right there. Okay. Description of the issues. And I always write, see attached. Okay. Just see attached. Okay. And then it tells you what they're asking for, description of the issues. Please describe the student's IEP educational program, and the reason you are requesting a hearing. what they don't tell you to do is say what they did. Okay. So let's do this. Okay. When you're filling out the forms, okay, what you have to do, I'm all red. Oh. When you fill out the forms, you have to cite a violation. That's the first thing you do. I'm going to show you that in a minute. It's the first thing you do. You cite a violation. If you don't cite a violation, guess what? It's not going nowhere. Okay. So you got to say, you don't have to cite a violation, like literally put in the regulation. You have to say, this, the first thing you say is the school district denied FAPE. First thing you say, school district denied FAPE. Okay. That's what you do. Then you're covered. Okay. So I always write see attached, and you're going to see why. Okay. And then here's a description of the issues. And then here's the other thing, the proposed resolution. So you have to explain the remedy, what you want from the school district. Okay. Hi, Barbara. I'm glad you're there. Okay, good. So then you have to sign it. Okay. You have to date it, which I forgot. And then you have, in Massachusetts, you have to check it off how you're going to do it. And you have to say, I'm sending this form to the opposing party. You have to send a copy to the opposing parties. All of them. Okay. Whoever you are citing, you have to send a copy of your complaint to the Department of Education and to the party, like the school district as a party. And if you guys don't know what a party is, and any of these words I'm using, I need you to tell me so that I can go and get it all done. Okay. I can give you this information. Okay. A party are the two entities that are in a hearing. Okay. Or three or four. I've had several. So it's the entities that are in it's the parent or the kid. It could be the department of, it could be the school district. It could be a state agency. All of these things are in there. Okay. It could be several state agencies. Okay. Because the hearing officer has jurisdiction over state agencies. Okay. And I'm going to show you later why that is. Okay. I'm showing you. I did it again. Okay. So let me go back up here so I can show it to you. I talk and I forget. Okay. So see where it says you have to send, I am sending this form to the opposing party. Okay. It's everything that you attach. I'm going to show you what I do. So that I said, does it tell you where to directly send it to the Department of Education on the docket? Yes. Usually. Usually it's right there. See, in Massachusetts, when you get the form, it has the address right there. And there you go. That's where you send it. Okay, in Massachusetts. Get the form, it's in there. Okay. And I'm going to show you what happens after this. After you send this in and you do all of this cray shit. Okay. And you have to make sure you sign it. You have to make sure you date it. Okay. And you can do this online. You can sign it and date it. There's a way you can do all of this stuff. And I'll show you guys how to do this stuff using PDF. Okay. So then what you say is that, you just check off other so it says, please check mail, fax, hand deliver. You always want to do other. You want to email to all parties and the BSEA or whoever the state is. Okay. Wherever it is. Massachusetts is called the BSEA. We have the fax number up there. And because of COVID on the BSEA website, it actually has the email address to email your complaint. It's called the BSEA pleadings at yada, yada, yada. Okay. I'll show you that later if you need it. Okay. And then, so now you guys wanted to see a complaint? Here's the complaint. This is how I do it. Okay. So right here, I write violations. Okay. To make sure that the hearing officer understands English, what I do is I copy and paste the BSEA authority. This is in the BSEA Special Education Due Process Handbook. They have a handbook in Massachusetts. Okay. So I just copy and paste all of that. And it says the BSEA has the authority. This is what the federal law says. The hearing officers have the authority to resolve educational disputes into Massachusetts. And this is for Massachusetts. So it'll say that. And then it says, and it's implementing regulations. And then it says, that's state law right here. 603 CMR 28, that's Massachusetts Special Education Regulations. Okay. And then it says the BSEA. Now we're getting into the federal stuff. It says the BSEA has jurisdiction to resolve educational disputes under federal law as well, in accordance with, here comes idea, 20 USC 1401 et sec. So all of it. 1401 or 1400 is idea. 20 USC is, do you not 20? I think it's Title 20 USC, United States Congress. That's what USC stands for. And then 1400 is the actual statute. Okay. Which is idea. What I use all the time are the regulations of the statute. Okay. And it says the Individuals of Education with Disabilities Act. And then it says, this is what Massachusetts does too. 20 USC 794, which is section 504, which is accommodations. Okay. If you're in Mass, could you share your advocates? Okay. Christine, I don't know if I told you, it was me. I'm her advocate. I'm still her advocate. Okay. I don't know if I answered you, but that's what it is. Sorry, honey. So in Massachusetts, the hearing officers also hear issues under 504. Okay. So if the school district violated your kid's 504 violations, which is all accommodations, okay, having to do with accommodations, you put that in your complaint too. It goes right next to denial of FAPE. You put that right in there, 504 violations, okay? So that's what I cite, because all of these regulations is what I'm telling the hearing officer is in my complaint. All of this is what my case is about, this crap right here. And I know you have jurisdiction. That's where it says, the parent asserts that pursuant to the BSEA hearing rules, the BSEA has the authority to hear all of this stuff. That's in my complaint. Okay, then I go, this is the first paragraph. Then I go to the next part, which is also copied and pasted from the BSEA due process manual, whatever it's called. And it says, these hearing rules are governed by 603 CMR 2800, 28.00. That is state law and federal due process procedures. And the Massachusetts, this is my favorite part, administrative, because I'll tell you guys about that. That has to do with the hearing officers and what they're doing in Massachusetts. A lot of states don't have separate regulations or laws that hearing officers are supposed to follow. Okay. In Massachusetts, they do. Good. Okay. And that's 801 CMR 1. Okay. I'll tell you why that's good later. So, okay, guys, this is what I do. What I say is the parent asserts. Okay. The parent asserts that all parties have been filed against, meet the requirements. Okay. And then in this instance, DDS, the Developmental Disabilities Services, they were also made a party in this case. So when I filed the complaint, I had two entities. I had the public school and a state agency as part of my complaint. Okay. Can you include what doctor reports from the neurologist, psychologist with the doctor's recommendations attached to the hearing request? Yes, that's in the evidence. Okay, Barbara. Hey, Ben, how you doing? That's part of anything that you include. Sometimes I cut stuff and paste it from the evaluations because that's what my hearing's about. This is what the school district didn't do, and this is what was in the evaluations. So that means that's a denial of FAPE. See, it connects. Okay. So then I go in. This is like just a prelude or the beginning. Just a little bit of history about the kid and why I'm doing this and what I know is under the jurisdiction of the hearing officer and the BSEA. Okay. So then the student has autism, echolalia, has a 40 IQ, serious behavior issues, inappropriate touching, yada, yada, yada. Hi, Michelle. How you doing? So I told him a little bit about the kid. Okay. And that he's in a private school. And the parent filed and is currently in a BSEA hearing on another issue. Okay. That includes the same school district and the private school. So I got 3 parties now. I got the public school, I got the Department of Developmental Services, and the private school, all in one hearing. This is the hearing that I won. Okay. The parent filed her invocation to the stay put. Always invoke stay put provision. If that's what you want for your kid, whether it's just a little bit or all of it, invoke your stay put, okay? So that you can continue to get the same services your kid's been getting, even if you disagree with them. Get the stay put so that your kid can get the services you do want, okay? So invoke the stay put. At that time, Evergreen School was not a party to the hearing. However, for some reason, the IHO allowed. Okay, this is me ratting out the hearing officer. We're in the middle of a hearing. We do a conference call, and the hearing officer thought it was okay to have a witness to the hearing who wasn't a party at that time attend the conference call. She's a witness. She's not supposed to do that. So I had a problem with that. At the time, Evergreen Center was not a witness and had been allowed to participate in a confidential hearing as if Evergreen was actually a party. Yeah, so I dropped that nugget in there because I knew what I was doing. But anyway, so now we get into, so that was just the opener, okay? This is what you guys want to talk about. The factual background. Remember what I told you guys? Facts, law, evidence. That's what you have to stick to, okay? So then I go into the private school. This is the private school violations. This is what they did. Remember, I got a 3-party hearing going on. So I got 3 sections. So, and then I start with on July 22nd. This is what this chick did. Everything in here, okay? Then here I go again on July 7th. On July 7th. And I'm putting information, cutting and pasting information from my evidence to support my allegations in my complaint. You guys see what I'm doing? Okay. So it says, responded to the advocate and others, Evergreen stated that the parent is either sign the extension agreement and, oops, wasn't supposed to see that, may remain at Evergreen. Okay. This is what they were doing at the end when he was supposed to leave the school. And DDS, the state agency, came in because they weren't ready for him to leave because they didn't have a place for him to go. And they made a deal with the private school that he could stay there longer until they found a place, which they did. He turned 22 in July. They didn't find him a placement until September 29th is when he left. So they had to pay DDS, the state agency had to pay the private school. Instead of the school district paying, the state agency paid. Okay. So I'm showing you this to let you see what I'm doing. You see, here's that. Okay. That's a date. See how I'm breaking things up? And that's a date. Okay. And then here's a date. And then I set a heading. Okay. I set a heading. This is the same setup I do most of the time. No. Okay, good. I'm glad you like it. This is what I usually do, even with my state complaints, to make sure that I'm not doing 2 different things, basically for the same thing. One is a state complaint. One is a due process hearing. We want the same thing. This is what I try to tell you guys. You can get the same result in less time doing a state complaint than you do with due process. That's the sucky part about due process. Barbara's case that we went to hearing on, 1 year. 1 year. I basically did it on purpose. But lots of attorneys do that. They delay. I did it on purpose. There was a reason I'll tell you later. Okay. So I say, for the record, the parent is doing neither and the student will be released and yada, yada, yada. So I'm talking about his placement. Okay. So here we go. So I talked about what was going on and I cited the dates and I make it bold and I underline it. Okay. So now we're going into another section. So this section is about violations. Now I cited the law. because in my experience, the hearing officer and the lawyers for the opposing parties, wait a minute. They like to say things like, Tammy's complaint was confusing, or I didn't know what she was talking about, or yeah, they do that all the time. So it's not just you. They did it to me too. Okay. So I decided a long time ago, I'm gonna make this real easy for these numbnuts. So what I do now is I do this. I cite the violation. Okay. And the best way I can tell you guys to find the violations is to make a list of what you think they violated, and then you can go look it up. It's way easier. I could show you guys how to do that so you always have it, okay? So in this instance, 603 CMR 1805 is a state law for private schools. Oh, I leaned way in. Because remember, I got a private school, okay? So they have different requirements in addition to IDEA they have to follow. So it says the letter to the parent from this person, but the parent did not receive the letter until July 7th. The parent asserts that the school withheld the letter to decrease the amount of time the parent would have to fight the ultimatum given this. Okay, this had to do with the placement from him going on July 7th was his birthday. So me and the private school are arguing about him staying there. They don't want him to stay there past his turning 22. And I'm like, yeah, no, we're not doing that. So I cite this law. And so I say, and then they violated, and they did that when the regulations are clear for Evergreen to notify the school district of the need for an IEP review meeting. They never did it, which would include a 10-day timeline in advance of the intended date of the meeting, and there was no meeting. So see, every time I want to get them on something, I cite the violation. I go look up the laws, and I put them in here. I told you guys this is what I do. See, there's a violation again. So I got the school, the private school, and a whole bunch of stuff. Okay. This is how I set it up. Okay. This is how I set it up when I file a state complaint, which I have a video on. Okay. Which at the end of this, I'll put a link in it. Okay. So this is what I'm explaining. You see how I broke it up? Okay. I talk about the termination plan. Always use things like the parent asserts. Okay. The parent asserts that the email sent to the parent, yada, yada, yada. The parent asserts that the email sent to the parent on July, yada, yada, yada. Contrary to this person understanding of DDS regulations, DDS is obligated to obtain informed consent. So I'm putting in all that shit now about the state agency. Okay. And everything, if you put in the dates, guys, okay, if you put in the dates and you put in the laws, everything starts to fall in line. Okay. It all starts to line up the way you need it to do. You do it first, do a rough draft on your own. And then it takes me a minute to do this. Now it takes me, I know what I'm doing, but I had to do one today, for instance. I did one today. It was a state complaint. Me and the parent had already talked about what the issue was. But what I did is I told her, I want this, I want this, I want this, I want this. When I got all of the emails and all the documents that I wanted in one section, in one spot on my computer, in a file, then I was able to go and look at all of those emails and look at the other evidence and go, okay, I need this, I need this. Oh, and then they did that and they did the other thing. They violated these regulations. Okay, so it ended up being even better than I thought on that complaint. But the way I came to that conclusion was the way I set up my hearings. Facts, laws, evidence. If you do facts, law, and evidence, your shit will line up and it will make 100% comments. It'll be real clear for any reader. Okay, this is the thing. You want to test something? Write up your complaint and give it to somebody who doesn't know anything about what's going on, doesn't know anything about special education. If they can read through it and fully understand what you did, you're golden. Submit it. Okay? That's how you do that, because they used to tell me all the time, I don't understand what you're saying. It's too ambiguous. It's too this, too broad. Blah, blah, blah. Now they stopped, because now I took a page out of their playbook, the opposing party's playbook, and now I set up my stuff like they do. So now they can't say this. I stopped all the nonsense. Okay. So now, so we go down here. Okay. So, another thing, footnotes. All the juicy stuff in your complaint is in the footnote. I didn't do it again. Okay. Right there. All of the juicy stuff is always in the footnotes. Okay. Even if you go read any, what do you call them? Decisions, go look at the footnotes. That's where the case law is that the hearing officer relied on. That's where the laws are where they go in depth and they cut and paste and they put everything in there. The footnote has a plethora of information. I hate that word, but it has a plethora of information. It's chock full of information that you can use in your hearings. Okay. So read the footnotes. Footnotes are just dynamite. Okay. So I put footnotes on all mine. I like it a lot, because then you don't have to waste time talking about it, because you just put the footnotes in the bottom. Now, if you have Word, Microsoft Word, you can go in and you just click on, I forgot which one it was, but there's a link, there's a thing, and it says references right in the toolbar. You click on references, and then you click on the thing and it says ABC, and then it has a little thing for footnotes, and it does it. You just put the cursor at the end like it is. Let me see if I can find it again. Where is it? It's on this page. Okay, wait. There's a footnote. Where's the damn footnote? The footnote is usually at the end of a sentence, and it'll have a little one. Okay, so I don't know where it is. I don't know why it's not showing up on this page. But anyway, it's somewhere on this page. And it will, if you just put it at the end, if you want to put a footnote, you put the cursor at the end of the sentence, you go up into your toolbar on your Word document, and you look for references. You click on the reference tool, and then it'll have another drop down, and it'll tell you ABC and have a little one next to it. You click on that and it drops it right into it. And then all you got to do is type it in there. Okay. What you're referencing. Okay. So now here I am again. So remember, I had 3 agencies. I had DDS, I had Evergreen, which is the private school, and public school. This is the public school. Now you have a whole section of them. I got 3 agencies in here. Okay. So now I talk about the hearing, and, in accordance with state, during the pendency of any dispute regarding the placement of services, the eligible student shall remain in his or her current. Yep, you got to put that in there right away. Okay. Because that's what I requested from the hearing officer in my complaint, that the kid has a stay put, and that's where he's staying. He's staying at the private school until this dispute is over. Okay. Also, the parents asserts she rejected the final IEP on the basis. Now, under Massachusetts laws and regulations, if the parent rejects the IEP prior to the kid turning 22, she gets a stay put. And she filed for hearing. She gets a stay put. Okay, so here we go. Parent also asserts. And then I tell them what the parent did. The student has attended. I'm giving him information. Cost $1 million for this kid to go to school there. $1 million. So then I'm breaking it down. But you guys see what I did? So it's broken down in sections. Okay. Sometimes I put like Roman numerals. So I'll put number 1, and then I'll put Roman numeral number 2, and I do it like that. But in this instance, I just broke it down with the name of the school. So, but you see, I don't make big, long, little short things going on, little short, and everything flows very evenly. Okay. It's very fluent when I'm talking about it. Okay. The student has not made any gains at this $1 million school. None. 0. And his behaviors have exponentially increased at an alarming rate. Yeah, that's what I wrote. Okay. He's going to turn 22 on July 10th. I don't know why I put that on there. It's not until July 7th. In pursuit of the parents requesting. Okay. The parent asserts that pursuant to this, the district is obligated to convene a team to discuss the developmental yada, yada, yada. And then that was a cut and paste. Okay. That was a cut and paste right out of the book. And then, see, here's the 2. Okay. Then I go down here and I put where I got that from. Cut and paste. Sometimes what I do is I cut and paste and I write retrieved from, then I put the website link. Yeah, that's how you do it. Okay. But that's what you do. Consent. So now I have a problem. So I write, here's another violation. Consent was never obtained from the parent to initiate or develop an ultimatum by the Evergreen School. So what I'm saying here is that the private school is giving us an ultimatum, and they never wrote consent. They never gave us anything to sign to agree to this nonsense. Okay. Parent involvement, which means that the school district, that the private school is also obligated under IDEA to implement all of the regulations. I know that's a hard concept in Massachusetts, but the private schools are just as obligated as the private school. I know it's a hard concept for them to understand, but truly it is. Okay. The school shall have procedures. This is what it says. Parent involvement. This includes both private and public. Okay. And this is all about what the public school was supposed to do and didn't. See, this is what they were supposed to make sure happened, but they didn't. So what I did is I broke down the termination procedures, and this is all, okay, let me do it this way. The public school is responsible and obligated for the implementation of the student's IEP while the student is in a private placement. Okay. And the reason why I have to cite these laws is because this is what the public school did not ensure took place under the state law for private schools. Okay. That's what I'm trying to say. So I keep citing the laws, and that's, I guess, what I really want you guys to pay attention to is that I cited the law, and then I wrote a paragraph about how that law pertains to the case at hand. Okay, so I tell them what's going on. So then I keep going down. I go down. This is another one. I forgot about this. I also included the Department of Elementary and Secondary Education. The Department of Education. I made them a party too. Okay. I made them a party in this case. And I write, DESE, Department of them, has violated conflict of interest regulations in which Reese Ehrlichman, the BSEA director, has a close relationship with the Pembroke Public Schools District's attorney from Murphy, Hesse, Toomey, and Lehane. That's a big law firm in Massachusetts. They represent almost half of the school districts in Massachusetts. And the BSEA director is like tight, like you would not believe with them about your kids' cases. So then I go do it again. This is the Department of Education. On May 25th, this is what I'm saying that she did. This is Reese Ehrlichman is the BSEA director. And this is the attorney for the school district. I'm talking about the little conflicts, but you see the date? There's a date. Then I cited the case I'm referring to. Okay. I got the names of people in here. Names. Okay. And then I say the parent asserts that the fact that MHTL attorneys, that's that law firm, and the BSEA director have such a comfortable relationship is concerning for the parent, as she is unsure who is actually calling the shots regarding motions, orders, or the final decision in her case. And this case is no different other than at least now the MHTL law firm and the BSEA director can legitimately have conversations regarding this matter without violating the students' rights of the students' confidentiality of conflict of interest laws, because I made them a party. I made the BSEA and the school district, the BSEA, a party to the case. Early education and care. So this is, I didn't make them a party, but what I'm doing is I'm showing all of the dates and violations of agency regulations that each entity had to pay. Okay. So I'm citing the laws. See, these are all the laws that are in there. Citing laws are really good, but if you don't know the laws, wing it. Just listen. Tell you guys a few secrets. The law is based on a reasonable person. If your kid has to go to school, under the law, they have to educate him. They have to provide your kid with an education. And that means all the kids, not part of the kids, not some of the kids, not on Tuesdays, all of the kids, every day, same amount of time. Anytime they make a change and they treat your kid different because your kid has a disability, that's a violation. 504. Stephanie, that is the same law firm that did. I know, honey. I guess you're in Massachusetts. I know. That's the law firm I beat, Mary Ellen Swarter. I beat her in Barbara's case. Okay? Yeah. It's an easy win, too. It's an easy win. Okay? So let me go back here. These are the people that I've been dealing with like for 30 years. I've been dealing with MHTL. Murphy, Cassie, Toomey, and Lane, or whatever they're called. Yeah, don't care nothing about them. So this law right here that I'm citing states that the licensee, which is the private school, must describe in writing the program's procedures for avoiding the suspension or termination of a child from a program. So they terminated my client knowing he didn't have a placement. But that's okay. I got this. We won in the end. Okay? And here we go. Developmental disabilities. Whoops. What's that? Oh, I gotta change it. Edit. Undo. Okay. And this is a state agency that was a party to the case. Okay. And so now I start saying the parent asserts that all of the above departments, all of those different agencies I cited, have violated state regulations that have hindered or removed the protections and rights of the student and parent, including DDS. All of those people violated all of those regulations. I'm asserting. The parent is asserting that. Okay. Are you available to chat at some point? Yeah, I am. Okay. Don't send me nothing. No, I will beat you. Send me nothing. Till after we have to talk first. Okay. Like you. Okay. And then I say, for instance, the student was deemed eligible for DDS services in February 2022. However, nothing was even started. This is why, okay. You have to remember, this kid turned 22. DDS in Massachusetts was supposed to do a whole slew of things before the kid turned 22 to make sure that the kid had a place to go. So in Massachusetts, DDS has big claim to fame now is they don't have any programs, they don't have any workers for the programs, yada, yada, yada. Okay, good. I don't care. Because you know what I know? My client's sitting in a private school right now. He's staying there until you guys can figure it out. How about that? Because I had to bring you guys into a hearing in order for you guys to go find him a placement. 6 months prior, you guys knew he was turning 22 on this date 3 years ago. You're bad. Don't care. So that's what I'm doing in this part of the complaint. Okay, so now I'm telling them all about what they did. The parent request was simply that she wanted the placement process to begin and to obtain answers as to what the process included. In the transition part, when a kid turns 22 or is about to turn 22, the state agencies are supposed to be coming to team meetings to tell you what they're going to do, what they offer, what they may or may not fund. Or your kid leaves school. They have to do that. They didn't do none of this with this kid. DDS and the parent met, and the referrals began. That was after I filed for a hearing. Okay? All of this happened after I filed against them and made them come to a hearing. Even though I knew the hearing officer didn't have jurisdiction over what I was requesting, the hearing officer to issue an order on. I told the hearing officer I wanted them to do certain things, and the hearing officer didn't have jurisdiction. Maybe in this case they did, but that would have been another case. But anyway, they didn't do anything until we started this process. They didn't send out any referrals for placement for any of their programs. They didn't do any of that until I filed for hearing. And DDS had all of the student records evaluated. They had everything. They had everything they needed. They need nothing from us. I made sure they had everything. Therefore, the parent asserts that it was all of the parties listed above that created this mess. That's what I said. This is what I said. And now it is the student that is paying the price and the parent that must agree to something that is unnecessary to benefit one of the parties and to clearly circumvent the stay put provisions. Because my argument is, remember at the very beginning, he has a stay put. I don't care nothing about what you guys' issues are. Bite me. That's what I pretty much said in that one sentence. See, they were trying to say, I filed a hearing because I wanted to stay put until DDS found him a placement. And under Massachusetts regulations, there's a whole bunch of stuff on stay put, rejecting the IEP, and then filing for a hearing to get that stay put. Okay. And I did all of it and I got it. Okay. The parent, and here I am at the end. The parent asserts that all of the parties either had a role in the gigantic violations of state regulations that protect students who are aging out of private schools and the agencies that have been identified to provide the student with services moving from school to adulthood. The parent asserts that the parties denied the student his rights to leave a school with dignity and have threatened to throw him out like garbage after the Evergreen School received $1 million for his attendance in the school. No joke. They paid over $200,000 per year. That's how much it costs for him to live there. And that's a matter of public record. 4 years. 4 years. The parent is invoking a right to a stay put and is not requesting a response from the hearing officer. It wasn't a motion because the hearing officer in one of my cases said, I put it in writing that we're invoking stay put. The hearing officer decided it was a motion. So she wanted to have a conference call on my motion. And I said, you can't have a conference call on a motion that was never issued. Your job is to hear and decide on motions. I didn't file a motion on a stay put. I invoked it. That's my right. That's different than a motion. So the school district's attorney is like, why did you do that? Why? Because you people don't listen. That's why I did it. We are having a conversation about the parent invoking stay put. Are you kidding me? Because it's not common knowledge with you people. That's why I did it. That's what I said in the conference call. I said, so when I'm having a discussion about a motion, that was never done. I didn't submit a motion. You can only hear motions. I told the hearing officer. Barbara, the law firm is against parents who fight against the school district and protects the school, knowing they break the law. See the crazy here? Barbara, the law firm needs to be shut down. That law firm only works with school districts. Yep. Okay. In my experience so far, districts spend more money fighting parents instead of, yep, you're absolutely right. I can't even finish the sentence because Stephanie asked Barbara, $1 million. The kid can't make a bologna sandwich. And that's not because he can't make a bologna sandwich. Okay. The reason why he can't make a bologna sandwich is because the school that he attended for 4 years that has over the whole school, if you guys can go look it up, it's Evergreen Center. Go look it up. Every single administrator that's on their books, okay, is a BCBA to some degree. BCBA with the PhD, all kinds of BCBAs. There's 15 BCBA. The owner of that school, BCBA with a PhD, and he let a girl work there with no license. I just looked her up the other day. She still has no license. Still has no license. I got a problem with that. Just saying. And I got a year. I can't deal with you. What? I'm just keeping it real, girl. So anyway. So this is me telling the hearing officer, don't start none, won't be none. Because I'm invoking it and it's not a goddamn motion. That's what I already said. And it's not requesting response from the hearing officer. That's why I said that. Because of what she tried to pull before. The parent asserts that she has given the advocate, my favorite thing to do to them because they're afraid of this. The parent asserts, I do this all the time. I just get the permission from the parent first. The parent asserts that she has given the advocate the authority to release any and all documents to whomever she deems would be able to help her in her quest to ensure her son's safety during his transition from school to adult living. Anybody I want. The media, social media, the newspapers, everybody. They don't like when I do that. And then I say it again. This is another thing you guys got to put in your hearings. I'll show you what I do. I don't think I put it in here, but I just said it. The parent is invoking the idea exhaustion requirement and reserves the right to amend her complaint. The idea exhaustion requirement, you got to put in your complaints because there's a whole case. I'll show you guys what that case law is. What you're doing is you're saying, I'm going to go right through the BSEA, right through the state complaint system, because the next step from here is court. I'm going to sue the pants off of you. What that statement is saying to them is, my intention, if I don't win everything across the board, my intention is to sue you in federal court. And I'm going to make sure I'm invoking the exhaustion requirement. That's what I'm doing. Because I'm going to sue your butts. See how that works? Yeah. You put that in there. You always drop that little nugget. These places are stunning, but they try to keep it pristine for tours. Oh, God, yes, they're beautiful when you go in there. Isn't that true? These schools are drop dead gorgeous. I mean, you would think your kid was going to be a king or a queen and going to get the best. If I'm telling you, if you read the transcripts from my hearing, you'll be like, what the are they talking about? I mean, it was so bad. It was disgusting. It's just disgusting that these people made the statements that they made under oath. Like nobody's going to see it. Everybody's going to see it. Because I'm going to give it to everybody I can to make sure that he gets what he deserves. That these people are not going to get away with this. Not on my watch. Absolutely not. They think they're free and clear. I do. Not so much. I'm not done. So, now. Okay. I'm going to beat you, Gene Kelly. What are you, a dancer? Anyway, the next thing you have to have, you must have what's called requested relief. I always say remedy, but this section, so I switch it up. It's either remedy or it's requested relief. I don't really care. So what you do is you're telling the hearing officer what you're seeking, okay? Everything you write, you say you're seeking an order. Okay, that the student remain in his current placement until DDS has located an appropriate placement to address his needs. The parent is seeking an order that DDS Evergreen Pembroke Public Schools initiate a team meeting to develop the termination plan. This is what you're doing. Seeking an order to do this. You're asking this is the relief that you are requesting from the hearing officer to make your kid whole. You're saying that your complaint proves they did all of this stuff wrong. And so in order to make your kid whole, this is what you have to do. This is what the hearing officer has to do. They have to issue an order to do this. They have to issue an order. And I'm going to show you some orders on another day because this is taking long. Because I got a couple more things I want to show you guys. Okay? Seeking an order must initiate. Okay? Because everything that you wrote, okay? When you're going for your remedy, what you're doing is you're taking your whole complaint and you're saying, okay, so this is what I said you crazy people did wrong to my kid. And because you guys did wrong, I'm going to need somebody to make you guys go do stuff. That's what the remedy is. What you're telling the hearing officer is, I want you to make them go do it. And the hearing officer has to write it in an order, and then the hearing officer signs it and dates it. And then when you get your order, it'll tell you like all of your rights on it, like how long you have to appeal the decision or how long they have, if they violate the order, what you can do to rectify this, all kinds of stuff. A bunch of information comes with the decision. Okay. We'll talk about that another day. Okay. But what you want is the hearing officer to issue an order, a written order that's telling the school or anybody what they have to do. The hearing officer said, just like in my order, the case I just won this summer, last summer, whatever, in October, whatever it was. The hearing officer issued an order that the school district go get that same BCBA who refused to do an evaluation do an observation of the kid in the community and said, go get her. It literally said this. I want you to go get her, and I want her to finish what she should have done in the first place. Go to the doctors and go take the observation, and then, if necessary, revise your FBA. That's what the hearing officer said, and you got 90 days. And she did it. So I have the revised one. Okay? But that was what we wanted. So the hearing officer took it, and the hearing officer said, okay. So that's what you do when you do requested relief. Now, your requested, mine is always long. I'm just shooting for the stars. Yours could be one thing. You just want them to do to evaluate your kid, or you want them to provide OT, PT, and for all the services. You want compensatory services, okay? So you can tell them that too. All right. So I asked for written assurances from the BSEA director that she will discontinue text messaging with MHTL attorneys. That's what I write. That's the kind of stuff I do. The parent is seeking a written order for Nicole Altman Moore and other administrative staff receive intensive training. That's another biggie that I use all the time, this part. For the staff to be trained in any areas that I went on, that they were found to be in non-compliance of. So I want everybody trained. That's what I put in it all the time. Apology letter, and that she reimbursed $1,500 by forcing the parent to file. She didn't do none of that. I put it in there just because I can. Okay. So then after you file this hearing, okay. Now, what I also do when I file my hearing, if I told you guys this, I bet you all forgot. Ta-da. See what I did? This was my evidence. So I got the facts, which includes dates and names of people and the sequence of events that took place. I have the facts. I have the laws, all the laws that I wanted the hearing officer to pay attention to, and that supports my allegations that they did this and this and this. Okay. And now there's the evidence, facts, law, and evidence. That's how you do it, guys. Okay. This is what you do. You make an evidence sheet. You go get all your evidence. Then you attach it. See? I just gonna put that part. Okay. So what I do is these after that page is all the evidence. Now I have a program, and my program allows me to, these are all PDF files. And so the program that I subscribe to allows me to take all of my evidence and to throw it into, see, like this. I can do this. See, it has that option. So here's my complaint. Here's all of this is the complaint. Okay. And right here's the evidence page, right? And now here's all the evidence that I used. So what I do is I can click and drag from my PC, and I can just drop it in there. Now, what you're supposed to do is write Exhibit 1, Exhibit 2, and all of that shit. I didn't put it in this one. I don't know why, but I didn't. Okay? So that's what I did. So then after you file your complaint, you get this. You get a hearing notice from whatever state you're in. In Massachusetts, you're going to get it, and it's going to say that. Okay? That's what it's going to say. So it'll have to the interested parties. It's the notice. This has to be done within a certain timeline, which we'll go over at another time. A lot of stuff we have to go over at another time. So then what it'll say is the Bureau, in this case, it says has scheduled a hearing. Okay, so once you file your complaint, and you have to forward it to the parties, the opposing parties that you're filing against, okay, then they send you a notice that the state schedules the hearing. Okay, it's an automatic hearing date. okay? But they have to send out this notice to you that includes all of this, okay? First, it talks about the laws that they're bound by in order to do this, okay? So in Massachusetts, they have Massachusetts General Laws 30A, okay, which is all about the hearing officer. And then they have Chapter 71B, which is all about the idea. 20 USC 1400 is the statutes to the idea. And then you have 504 regulations, which is 20 USC 794, okay? And the regulations promulgated under these statutes, okay? And then they say, go get the book. This is Massachusetts has hearing rules. They have the hearing rules for special education appeals, which is a good book for anybody to use in any state. If you can't find yours, go get ours. It's real easy to find, okay? But ours pretty much covers what most school district, most states use, but it'll give you an idea at best, okay? Even if it's not exactly like yours, it'll give you an idea. Some states, like in New York, I don't think they even have a rule book, okay? I don't even know what they're doing, and I've been there several times. They have special education laws, but they don't have rules for going to hearing. Massachusetts does, which is a wonderful thing. So then this is where they give you your hearing date, okay? And they tell you where the hearing, this was old because we don't even do that anymore. I don't even go to the hearing. This is before COVID. And here's the name of the hearing officer. So this is where you get your information. So when you get this notice, pay attention to it. Don't throw it in the trash or something, okay? You got to keep this. Go get you a nice file folder. So every time you get something in the mail from these attorneys, you stick it in the file folder, and this is on top of the file folder, okay? So you know at all times when your kid's hearing is. Now, this could change. This is an automatic date. This is not written in stone. In fact, 9 times out of 10, somebody's going to file to postpone the hearing. So this, oh, good. Oh, that's wonderful. Oh, the lights go out. All right, guys, I don't know. Okay, good. It will last a little longer. But anyway, so I'm going to end right here because then I'm going to show you guys the actual I wanted to show you the complaint. Now I'm going to show you the motions. Next week we'll have all of these motions here because my lighting is done. I don't want to stay on now. So anyway, so this date is usually changed, okay? Because somebody's going to file a motion to postpone. And then deadlines, okay, here are your deadlines. For filing a response, the school district, whoever files the hearing, the opposing party has to, they absolutely have to respond. If they don't, they lose. Oh, okay, good. We're just going to keep doing that crazy mess. Okay. And then if you don't fill out your form right, remember what that form said? Here it is right here, to challenge the sufficiency. And these are the dates they have to respond. Now, a lot of times what will happen is the opposing party will get this notice, and first they'll file, because you can't do anything until you get this notice, okay, from the state that tells you when your hearing is and all that good jolly stuff, okay? This sucks. I think I'm gonna punch these lights. Anyway, you got to know who you're submitting stuff to. So after you file the complaint, you can't do anything until you know who your hearing officer is. So don't file any motions or anything until you get this notice, okay? Then don't file anything, because what you have to do is you have to wait. Maybe that'll work. I feel like I'm under arrest. Oh, this is wonderful. So anyway, you have to wait to find out who your hearing officer is, okay? So, and you have to wait for the school district to respond. Now, a lot of times what they'll do is they'll respond and they'll ask for a request to postpone immediately, okay? You can even ask to postpone hearing because that date's not good for you, Okay. So either way, you're going to get one of those notices about postponing. We're going to talk about postponing next time. I'll show you the forms. It's real easy. Okay. The lighting situation, I might be able to do it. But you really want to read what the school district's response is. Now, don't get all crazy when you read it, because 9 times out of 10, they're going to say the school district denies the parents' allegations, and they're going to say denied. For everything that you said, they're going to say we deny this, we deny. That's what they do. Okay, so expect that to happen. All right. Now, if you don't fill out the forms right, or you didn't send them the paperwork, because you have to do it at the same time. You can't wait a week, first send it to the state, and then wait a week and send it to the school. You got to do everything at the same time. Okay, everything has to go at the same time. So when you do that, then you're good. So you're going to get a response. Read it. Okay, don't do anything. You only do stuff when you get motions. That's the only time you do stuff. If the school district said some wild, crazy stuff, let it ride. Unless they filed a motion, if they file a motion to dismiss your case, now you file a motion. I'm going to show you how to do that next week. I'm going to show you how to actually file the motion. But before I could go on to show you how to do the motion, I had to show you the complaint part first, okay? And the postponement part. The motions are a little more difficult, but I guess I could show it to you right now. It's not too bad. I'll show it to you. Okay, so this is, and then after it does all of that, then down here, this is the automatic date for the hearing officer to issue an order. Okay, it's automatic date. So now, so it says you have 5 business days prior to the schedule. Okay, there's a whole nother part of the due process, because when we get into it, I'm doing the motions and stuff and the postponing, but when we really get into it, there's all kind of timelines. This is why this is not fun. But at least if you guys know what you're up against and know what you have to do, you also now know what an advocate or a lawyer is supposed to be doing, okay? And if you have an attorney, they need to give you this information, okay? Whatever the school's saying, you need to see it, because the lawyer doesn't know what you might have. And if the lawyer is relying on the school district to give them the stuff that you need, you're screwed. Don't use that attorney. They need to talk to you about your evidence. What do you know? They need to talk to you. Be careful with lawyers. Okay? I'm just saying. Not all of them are bad, but just saying. They're in it for a different reason than you are. Okay? I'll show you this. So over here, see, this one includes a telephone number. That's the due process. That's for the state. That's a telephone number for the state, for the department, for the BSEA. I'm sorry, I'm tongue-tied. Okay? And so unless this information is, you have to read this too. Okay? It talks about, okay, here it is right here, what I was just telling you. This date is subject to change if a party successfully challenges the sufficiency of the hearing within 15 days. That's why you got to always read the footnote. See right here, it's a footnote. That's a footnote. Always, that's where the good stuff is. Okay. Unless otherwise directed by the hearing officer, in the event the school district cancels school. Okay, this is about the hearing date. Okay, but this right here is something different. So, the party has 15 days to challenge. That's up here. Filing to challenge sufficiency if they have 420. That's 5 days after. What's this? I don't know why it says 15 days. Oh, 15 days of within the 15. What is that? Challenge the sufficiency of the hearing request within 15 days of its receipt, or parties have completed or waived resolution. It's a whole nother thing. Resolution meetings are a whole nother thing, which I don't recommend at all, personally. In Massachusetts, they're totally useless. They're not binding at all. Mediation, on the other hand, that's something different, but it depends on what you want. It's a whole different story. It's a whole different video. Okay. So here we go. Timelines which appear above are premised on the assumption that the hearing request filed with the opposing party and the BSEA on the same day. See what I said? In the event this is not the case, the date of filing with the opposing party governs the timelines, should be adjusted accordingly. So I'm telling you, the good stuff is in here. Then it says, within 10 days of receiving a request, the other party must send a response. A response to the filing party. So you filed a complaint against the public school. The school district must respond to you. So they have to send it to you, not just the hearing officer. They have to see, now they have to send their response to the hearing officer and to you. That specifically addresses the issue raised in the hearing request. They don't get to talk about all over the place. They have to answer what you are accusing them of. That's what they have to do. A school district need not send a response if it has prior written notification to the parents in reference to the issue raised in the hearing request. That's never happened. They always have to do it. Okay, the challenge, sufficiency challenge, must occur within 15 days of receiving the hearing request. So the opposing party, must do this within 15 days. And that's the federal laws. Okay? So that's the hearing notice after you filed your hearing, after you submitted your evidence. And you always have to, listen, guys, you always have to submit evidence. And you always have to put your evidence behind your complaint. And you always have to make sure everybody gets everything. No playing. Hey, Kim, how you doing, girl? Okay, you have to remember everybody has to get everything the same time, and everybody has to get everything. That's just the way it is. Okay? So now, let's do this. So, let me see what this is. Okay, let's do the motion. Okay. So, well, let me tell you this. A motion is you're asking the hearing officer to do something. It's a request for the hearing officer to do something. It's a request that you're making to the hearing officer to do something in the form of a written order to the opposing party. That's what an order is. You're asking a question of the hearing officer. Okay, keep that in mind. So when you set up your motion, okay, you send it to the hearing officer. Okay, so this is the hearing officer. Okay, it's all the information. You have to put in the case number, the hearing officer's name, okay, and all of this stuff. You have to do that. Then you write motion to, whatever it is. Okay, so in this instance, it's a motion to amend the hearing I already have. That's already there. So you can change your motion, or you can amend your motion to include new stuff that you just found out about, which is happening right now with me in another case. Okay. So if you want to add, you can't just assume when you're in a hearing, you can only bring up stuff that's in your hearing request. You can't go into hearing and go talk out there in left field somewhere about stuff that you didn't put in your hearing, because first thing that's going to happen during the hearing is the opposing party is going to say, I object, and the hearing officer is going to say, why? And then the opposing party is going to say, her question is beyond the scope of the current matter before you. And the hearing officer is going to say, what do you have to say? Well, what happened in my case is I said, she's right. It is. Let me rephrase. And everybody started laughing. But you really have to make sure that you're constantly looking at what you alleged in your complaint. It's not an opportunity for you to go all over the place. Don't do that. One, you piss off the hearing officer. Two, you aggravate the opposing party as if they're not aggravated anyway. They don't like us in a hearing. They don't like us. They think this is just the realm of the lawyers. Bite me. So I've had to tell a few hearing officers off about that. One of them was Lindsay Byrne in Massachusetts. I had to tell her, I know what your problem is. You don't want anybody in front of you that's not a lawyer. Get used to it. I'm coming up here all the time. And I proceeded to do just that. Then I busted her for doing stuff she wasn't supposed to do. Don't care. Tammy, don't care. So, to make sure that you have an easy flowing hearing, I'm going to show you guys how to do this too. What I do before my hearing, I already know who my witnesses are because there's a whole nother, we got to talk about that. But anyway, the witness list, okay? You write up your witness list, you submit them with your book, and you tell the hearing officer you need subpoenas. And what happens is you guys come together and you say, well, those are all school witnesses, so they're going to come anyway. We don't need witnesses. And I tell them, make sure they come. Because if they don't, I'm going to be mad. I'm going to file a motion to postpone. Right in the middle of the hearing, don't care, because they're coming. So anyway, they usually show up. I've never had a problem with that. Yes, so true about being biased against us because, yeah, well, you guys don't have any money. The only people that go to do this stupid stuff is low income, middle income, and just plain poor. Nobody in their right mind who has enough money to pay $200,000 a year for your kid to go live at a private school. Unless you're loaded, way up here, high income. So yeah, they mess with you all the time. But I'm telling you guys this, what you can do is to make sure that you have an easy flowing hearing, make sure your witness list matches your evidence. Cannot ask witnesses about evidence that they don't know nothing about, that they never saw before, that they didn't have nothing to do with. You can't ask Mary about an email that was written by John, and Mary ain't nowhere in the email. You can't do that, okay? You can only ask a witness about information that they did. That's how you win. That's how you do it, okay? You have to make sure that your evidence matches your witnesses. If it doesn't, you're going to get a lot of objections. And they're going to say, that witness doesn't have anything to do with this. So match your stuff up, okay? But we're going to talk about witnesses later. Everything is later. But I told you this is big. This is huge, okay? So you have to, so when you write your motion, you're asking a question of the hearing officer. You're asking her to do something. So in this instance, I'm amending my hearing. Motion to amend. I filed a motion to amend the current matter that's before this particular hearing officer. So this is what I say. The parent is seeking to amend the current matter before the BSEA to include the latest information regarding the transition to the Massasoit Community College, yada, yada, yada. That's what I'm asking her to do. I'm asking her to allow my case to be amended to include this new information. That's what a motion is, okay? So this is the first paragraph. So now, after I say that piece, then I say, however, so I said, the district agreed to fund and to place the student to provide her with needed transition services to adulthood, yada, yada. However, the Macy program is not included in my thing was it wasn't in the student's IEP. Okay. So this is what I'm amending my hearing to include. That this program that the kid is going to has to be included in her IEP. Okay. The parent asserts that the district's actions have denied FAPE, which is basically because the district failed to put this in her IEP. So we have no goals. We have no objectives. We don't even know. There was one line that said this in the IEP. I kid you not. That was it. Okay. So then I cited again, the district's actions have denied FAPE and among other violations. And that's another key thing that I do. Okay. See this right here? Among other violations. That way, just in case you might have missed one, you got among other violations. Just in case you might have missed one. because it says this says 320 to 324. But what if it went to 328? Among other violations. See? And then you say I say there have been many violations thrown at the parent and advocate by Jessica DiLorenzo and their attorney, Venetia Sal, alleging that the parent and the advocate are hindering, they actually said this, the student's ability to access FAPE. However, the records will demonstrate, because remember, I'm amending what I've already done. So I'm telling the hearing officer, the records will demonstrate in this amendment that it is the district that has willfully and intentionally denied FAPE to the student with their repeated refusals to fund the Macy program, the denial of the parent to fully and meaningfully participate. This is what I'm alleging. Okay, all of this is what I'm alleging they did to my client and my parent. Okay. And then I say, remember these little tidbits for the record. You want to put little phrases like that in there because you're letting the hearing officer know for the record, yada, 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 yada. This is this. Okay. What I'm saying right here is for the record, the Massasoit Community College and Pembroke District have been provided the legal court-appointed guardianship for the record. Okay. So the fact that the student cannot, without the parent being present, make financial educational decisions without the parent. This is what I'm telling you. This is for the record. This is a fact. It's a fact the parent has legal guardianship. It's a fact that the student cannot make financial and educational decisions without the guardian being there. It's a fact. So I say for the record. Okay. And then I tell the hearing officer that part of my amendment, the parent will demonstrate that the district has failed to ensure the student will be enrolled in the program in the fall semester. Therefore, the district has failed to provide the funding and is forcing the student to fund. They actually sent my client the bill to go to the program. And then I'm citing at no cost to the parent. This is a violation at no cost. She's still in public school. Yeah. The parent asserts, here we go again, the parent asserts that she was denied access. So as you can see, I'm citing the laws. I'm telling the hearing officer, these are the people. Here's the people, okay? The parent has legal guardianship, education pursuant to the idea. Here's that, okay? I'm telling the hearing officer, these are the facts. I'm giving the hearing officer the facts. Okay. The parent asserts that all of the records indicate that her daughter wanted to go to work. So when I say all of the records, they're attached to this complaint at the very end. So you want to use words like for the record regarding any facts. You want to say the parent asserts. And what you're saying is the parent alleges that. The parent is accusing them of this. So instead of saying those two words, you say the parent asserts that. Okay. And the parent can assert whatever the hell she wants. But what you're going to do is you're going to assert it, but you can prove it. What we're doing here is we're describing what this program actually is. So the parent asserts that the Macy program offers much more than art classes, because this is all we were told. So then I put in everything because I got the information, and this can be found online. Okay. However, that is not what was discussed or offered to the student for approximately $1,200 plus and materials for the art course that was discussed during the Zoom meeting that the parent could not attend. Okay. So they denied the parent the opportunity to participate in this meeting with the student and the school. So this is what we're doing, okay? See, the parent asserts again. And then there's another paragraph. So when you read it, it flows, because every time you're going to make another assertion, you put it in there, the parent asserts. Why is this not working? I don't understand. Parent asserts. The parent asserts. And you're making factual statements every time you say that. Statements that you can prove. That's how you write it. See, the parent asserts. And then you put a little explanation in there, because this is just what you're saying the school district did. You got the facts, you got the law, you got the evidence. the meat of your complaint is going to be delivered through testimony and evidence. And then the hearing officer is going to make, okay, wait a minute. The hearing officer is going to make a decision based on a preponderance of evidence, which includes testimony, okay? That's taken under oath, under pains and penalties of perjury. That's what I'm saying, okay? So that's basically what a motion includes. So when you're writing a motion, you're requesting something from the hearing officer. You're either requesting to add this information to your complaint. So this now is before her. Because if you don't do this, then the hearing officer is going to tell you, I'm sorry, I can't hear that. That's not before me. That's what they're going to say at a hearing. I'm sorry, I can't hear that because it's not before me. The other side's going to object, and the other side's going to say that's not before you in this hearing. Yeah, but there's no yeah buts. No, you're gonna yeah but the hearing officer and the opposing party, but it doesn't matter. Because when the hearing officer goes back and the hearing officer reviews all of this information, she's also going to review the part where you tried to throw something in there and it wasn't before her, and she said that's not before me. And here's what I want you guys to understand. When you get your written transcripts, because you have a right to them, in the back of the book of your written transcripts, so you can literally look up every single word that was said separately. So this is what it'll say. So let me show you. So it'll say, so let's say before me. If you want to look up the word before or not, like you can look up words that say, if you write the word before, if the word before was used anywhere in the transcript, in the back of the book, you can look up the word before. And it'll tell you how many times and what page it's on. So that's how you can find the word. That's what she does. So every single time you try to bring something up that's not in your complaint, it's going to be objected to. The hearing officer is going to say, I agree, it's not before me. And they're going to say, it's going to be objected to because the school district's going to say it's not before me. You're going to say, yeah, but. You're going to give your objection as to why it could be. And the hearing officer is going to say, yeah, but it's not before me. I can't hear it. It has to be before me. And you have ample opportunity to put stuff before the hearing officer. This motion to amend, you can do a motion to amend anytime 5 days before the date of the hearing. 5 days before the hearing. Okay? So you have ample opportunity to file a motion to amend to get more information into your hearing. And all you have to say is motion to amend. Okay? That's all you have to do is say motion to amend. And the rest of it, you say the parent is seeking to amend the current matter before the BSEA to include. You don't want to amend it so you wipe out what's already been done. So you want to say you're filing a motion to amend to include this new information. Not to throw out what's already there, but to include this information. I do that because the school district's attorneys, they love to play games. So to make sure that I'm covered, I cross my T's and dotted my I's, I put that in there if I'm filing a motion to amend. Okay? What time is it? Okay, we're going to do postponement real quick because it's just a form. Okay, so you have the right to postpone your hearing request. Okay, whether you filed a hearing and got that date that we saw on that other paper that we saw here in the hearing notice. Okay, you can file a request to postpone. And this is the form that you get in Massachusetts, but every single state has it. Every single state has documents to either advance or postpone your hearing, okay? So it says right here, this request is for, please check one. You check postpone, okay? And then you write the student's name, the district, and the case number. This is the same setup, okay? So then you put the name of the hearing officer. You got the hearing number and the hearing officer's number. And then you say it's requested by the parent, okay? Or sometimes during a conference call, a discussion will take place and everybody agrees that the hearing should be postponed until a certain thing happens. There's lots of times that happens, especially in my cases. It happens all the time. So anyway, both parties could agree. And if everybody agrees to a certain date and a time, then the hearing officer will say, okay, who wants to write the postponement? And then put it in for the dates. And then you put in the reasons. You have to put in a reason why you're postponing it. It could be for anything. We don't get stupid, but it could be for anything. It could be that you're leaving the country and you're not going to be available, or that you're going to be hospitalized, or that you're building a house and you're not available, whatever. Or you're still waiting for evidence from the school district. They haven't provided you with the evidence, or the hearing officer hasn't answered any motions that you filed. And so until the hearing officer answers the motions, you can't move forward with your hearing. Literally, it could be anything, okay? With bad reports, with missing data, and reports were done wrong. Yep, okay. If you are the parent writing this, do you use the verbiage the parent asserts? Yes, I do. Because it's going into a file, and it's going into a record, and so other people are going to read it. I'm telling you, I have a lot of my stuff online, and it's better when it's read by somebody and it says the parent. So it's just easier because I'm always writing them. That's why I put the parent. But I would still, if I was the parent and it was my kid, I would still write the parent asserts. I'm not going to say I assert, or I'm alleging that. It just doesn't sound right, like legally, professionally. So I use that. Yes, Stephanie, in answer to your question. I just feel like it's more professional, I guess, because they're always trying to make us look bad and say we're not professional and we're not lawyers, and nobody wants to be a lawyer. But for real, I don't want to be a lawyer. No, I don't. But anyway, so this is where you put why you're requesting, and it could be a big long story. It don't matter, but just keep it real, okay? And just say why. And then proposed alternate date. So you have to put a date in the future that would be convenient for you. Now, if you haven't already had a discussion with the other party about this, like through a conference call, then chances are the school district is going to come back and you're not going to know if this is convenient for them. So you just put the dates that are, okay, proposed alternate dates agreed upon by both parties if possible. So if you're in a contentious relationship with the school district, you're not going to do if possible. It's not possible. So you're just going to put it in there and you're going to keep it wide open. What I like to do is go out, like if you go out 2 weeks, you give yourself enough time to do whatever you need to do for the reasons why you're requesting the complaint. Okay. Do whatever you give yourself enough time. Okay. I mean, I just had one case and it went out like 3 months because the parents were out of the country. So we had no choice. So you can propose, you can put your dates in here, and the hearing officer may not be available on the dates you're proposing, and neither will the school. So what will happen is everybody will chime in, and then the hearing officer say, well, let's have a conference call on the parents' postponement. And so now you got that, okay? But give yourself enough dates and be prepared, because just because you said you're available on that date doesn't mean everybody else is, okay? And even if you agree with the school district, you guys do talk, and you agree to change the date, the hearing officer may not be available on that date. So it might change anyway, okay? Just know that when you postpone it, it's going to change the timelines for you getting a decision, okay? It extends it, okay? And then the hearing officer will send you a letter, and she will tell you if your request was denied or approved. 9 times out of 10, it's approved, okay? I've never had one that wasn't approved. I don't know what's going on, why there's so many pages. Okay, cool thing. Here's the instructions, okay? The form must be completed because of proposed postponement and must be sent to the assigned hearing officer. So you can't do a postponement until you get the hearing request form. If you don't like that date and it doesn't work for you, as long as you have that notice of hearing, which will have the date on it, That's when you first find out when the hearing date is. You will have a hearing officer's name on there, and then you can file the postponement request. Okay. And please check the appropriate box. A copy of the request must be sent to the other party. So like I said, unless circumstances dictate otherwise, requests must be received by the hearing officer no later than 5 days before the scheduled hearing date. Told you. Okay. And that's it. Okay. Now, there's other types of motions, which I think I can go over that with you next week. I hope this was helpful. This is not the end by any stretch of the imagination. No. So I tell you guys all the time, go the complaint first, then do this. Now, sometimes you're forced into a hearing. I know that. That's why I'm telling you guys how to do this shit. Sorry. I don't think I'll drink wine anymore in my lives. I'm a little too loose with the lips. Anyway, so I think you were in a previous life. I don't know what that means. But anyway, it's difficult. I'm going to tell you guys the real deal is it's very difficult. But you can do it. It's not something you can't do. And there's no guarantees. Listen, guys, I want you to understand this. There's no guarantees if you have an advocate, if you have an attorney. Thank you. There's no guarantees that you will win if you have an advocate or an attorney. If there's no guarantees, then I'll do it myself. Screw it. I'll go find that girl. What's her name, Tammy? She'll show me how to do it. I can show you. I'm going to show you guys how to do all of it. How to do your witness list, how to do your exhibit books. I mean, there's a lot. How to file a motion for production of documents. I got a handy dandy one. It's real cool. But how to do your motion for production of documents, how to set up your questions. You have to prepare for the hearing for real. This is not a team meeting. Oh, I'm glad. I hope I was helpful. I hope you guys got this. And like I said, what you can do is go back and review it. At some point in time, I'm going to stop putting chapters in it so you guys know. But it's a whole bunch of editing I have to do. And I think you guys like this. You guys, let me ask you a question. Do you guys like the lives better than me just posting videos? You know, doing it and then posting it? Do you guys want this? Thank you, you guys. Thank you for all of the appreciation. I love it. But I like doing the lives too because they're fun. And now I know how to do, get Barbara in or get other interviews. And so, I might approach some of you and ask if you want to come on the show and we could talk about whatever you want. You tell me what you want to talk about and I can ask you questions and it'll just be at the beginning like I just did. But I just personally like, you do like the lives. A lot of people like the lives. I like the lives too. Every now and then I think I'm going to do a little short one, a real short one, maybe a TikTok or short. But anyway, I want you guys, just let me know which ones you guys prefer because either way it's going on YouTube. So I'm good. I don't care if it's long or not. I love watching long ones on YouTube. But I don't know, a lot of people who don't have the attention span, they want to hurry up and get it over with. So just let me know. But I still need you guys to subscribe to my channel. It's going up and I love it. So thank you, Kim. I still need you guys to subscribe to my channel. If you have any questions about this video, go to my YouTube channel, click the subscribe button, click like and share, and make a comment, and I'll answer your questions down there. Okay? Don't send me an email. Don't inbox me. If you have a question, put it on this video on YouTube. Okay? So it's already there. So that's all you have to do. And then that way, the more people I get, and it is increasing, and I really want to thank you guys so much. And I'm doing more of them. The more you guys help me increase it, the more I'll do. I don't mind doing them live. I'll also do some other ones too, but I don't mind doing lives. It's fun. So I hope you guys had a good time. I hope this was helpful. And my goal is to give you the information so that you have it and you can use it as leverage for sure. because you know a little bit more than you did 2 hours ago about this process, and you're still at the beginning, okay? I'd rather have you know about it, and then you can make an educated decision as to whether or not you want to go to hearing. Do I have to hire an attorney? All of these questions, okay? Only to what? Lose anyway. One day we're going to do a whole thing on the stats across the country of who, what are the stats as to the parent winning, and it's low. Now, it's better, I think, with state complaints, and it's quicker. That's why I'm telling you guys all of this. So you can make a decision as to whether or not you want a state complaint or a hearing to resolve the issues with the school district, and how long does it take? Eat both of them. Okay? So I want to thank you so much. I'll see you guys next Thursday. Okay? Love you all. Remember, I know I'm not for everyone. I know. I'm me. But I really love you guys, and I'm glad you came. Good night. You guys have a good week, okay? Thank you so much. Mwah.